Reeves Immigration Law Group now brings you immigration law on your side.
All right, welcome to another Immigration Law on your side right here at PHLV Radio. Kalagitnaan na ng July. If you're watching us in our premiere episode of this premiere streaming of this episode ng Immigration Law on your side right here at PHLV Radio. And if you're watching us on our podcast platforms, on our on-demand platforms, welcome pa rin po sa PHLV Radio. Ito po itid sa inyo ng ating mga kaibigan from Reeves Immigration Law Group. And as I said, nasa kalagitnaan po ng summer dito sa Las Vegas, kaya mainit. Pero katulad po ng sinasabi natin, always mas mainit ang pinag-uusapan natin sa immigration. Mga kaibigan, napakinggan nyo na yung 3-year bar or 10-year bar na hindi kayo makakapasok dito sa United States. Ano nga ba ito? You know, anyone who enters the United States without inspection or yung tinatawag na EWI, or they stay beyond the approved period of their visa, they are considered out of status or yung tinatawag na overstay. O kabayan, overstay ka na. Palagi niyong naririnig yan. Even if it's only for 1 day. Consequently, they should leave the country right away to avoid invoking a barrier to re-entry at a later time. Itong napapakinggan yung mga bar. So with us tonight is a partner at Reeves Immigration Law Group, Flomi Javier Diza, naka-birthday lamang. Happy birthday, Attorney Diza. To help us understand how the 10 or the 10-year bar affects you. So mga kaibigan, welcome na po natin si Attorney Diza via Zoom from San Francisco, California. Magandang gabi po sa iyo, Attorney Diza.
Maraming salamat Kuya Johan at magandang gabi din sa iyo at sa lahat ng viewers and listeners natin. Maraming salamat sa mga lahat ng mga bumate ng happy birthday sa akin. At alam natin another year, no, na lumipas at sana okay na tayo, wala na pong pandemic. So mainit ang ating pag-uusapan ngayon, as you mentioned, no, dahil summer na, pero ang San Francisco medyo malamig pa rin dito, nasa 60s pa rin ang aming weather, no, dito sa San Francisco, kaya maganda ang ating weather kahit summer dito. But anyway, itong 3 and 10-year bars, palaging marami nagtatanong sa atin dito, lalo na ngayong pandemic na maraming bumisita sa US at sila stuck dito at hindi sila makauwi dahil siyempre may mga cancellation ng flights at hindi na sila nakabalik, either na-deny yung kanilang extension or nakalimutan na silang mag-extend or dahil sa nagkaroon ng family or medical problems dahil sa COVID, hindi na nakapag-file ng extension. So very timely din ang ating pag-uusapan ngayon. Ang 3 and 10-year bars ay create ito ng 1996 na batas. Ito yung tinatawag natin na Illegal Immigration Reform and Immigrant Responsibility Act. As we all know, well known sa ating mga practitioners na tinatawag natin IRA of 1996. Ang batas na ito ay nag-impose ng re-entry, yung pagpasok ulit dito sa Amerika, binaban ka, di ba, on mga applicants na nag-accrue ng unlawful presence dito sa United States. Pag sila ay papasok ulit sa US. So very important na malaman din natin ano ba yung unlawful presence. Nabanggit mo nga kanina, Kuya Johan, na kahit mag-stay sila ng kahit 1 day lang, di ba? On their allowed stay, they're considered to be unlawfully, staying in the United States. Pero ang unlawful presence, Kuya Johan, ito yung mga immigrants o yung mga applicants na or mga tourist visa or people who enter in the United States on a specific visa na nag-overstay beyond the period of their allowed admission, right? Yun ang unang-una. So for example, mga kababayan, kayo po ay tourist visa at nabigyan ng 6 months lang, di ba? Kung nag-stay na kayo ng 6 months and 1 day, nagkakaroon na po kayo ng unlawful presence kung wala pong extension. Yun yung unang-una. Pangalawa, yung mga nag-entered without inspection. Bibihira natin nakikita ito sa ating mga kababayan Pilipino dahil usually may mga visa yan eh. So either we have a visa or tourist visa, employment visa, or you came in with a different name, meron pa rin inspection. So usually itong mga nag-EEWI, yung tinatawag nating IWI, yung mga Mexican or people from southern border na nag-cross the border. May mga ilang mga Pilipino din, Kuya Johan, na dumadaan ng Mexico without inspection or sa Canada na without inspection. But with the present time, mahirap na, lalo na kung sa Canada po kayo mag-enter without inspection. So nagkakaroon po ng unlawful presence if you stay beyond the authorized period. Now, pumapasok po yung 3-year bar kung ang overstay nyo ay more than 6 months. 6 months from your allowed stay. So for example, dumating po kayo ng January 1 at ang expiration ng inyong tourist visa ay June 2, right? Hindi kayo nakaalis kaagad at sabi mo, dito na lang ako, mag-TNT ako, then you realize na ayaw mo pala, mahirap pala ng TNT. So umuwi po kayo after June 2 the following year. So more than 6 months na yung ano mo dahil let's say so June 2 halimbawa ang expiration ng inyong status, and then umuwi po kayo ng after 6 months, which is about December, June, July, August, September, October, December 3. Umuwi kayo ng December 3, that's more than 6 months, right? Then doon po mapasok yung 3-year bar. So kahit sabihin po ninyo na attorney, valid pa ang aking visa, di ba? So meron akong 10-year multiple entry, right? So kakagamit mo lang yung visa, first time mong pumasok dito sa US at nag-overstay ka ng more than 6 months, hindi mo na magagamit yan. Automatically na revoke ang inyong visa kahit sabihin mo meron ka pang another 9 years. Na pumapalo naman yung 10-year bar, Kuya Johan, kung ang overstay mo ay more than 1 year from your allowed stay. So for example, yung ating scenario kanina, nabigyan po kayo hanggang June 2, umalis kayo at ang validity mo is hanggang June 2, umalis po kayo after June 3 or June 2 of the following year. Ibig sabihin more than 1 year, doon pumapalo yung 10-year bar. Now, take ko mga kababayan na ang 3 and 10-year bar only applies when you enter the US and you depart. Diba? Depart after the expiration of your visa or your status as we mentioned. So kung kayo dito, nandito na at nag-stay kayo dito at naghintay kayo ng petition ng inyong magulang, right? At maging available na in the future, di ba? Let's say 5 years pa, 10 years pa, hindi ka pwede mag-adjust dito or magkaroon ng green card, right? Unless, of course, umalis ka kasi wala kang status. But yun ang pag-usapan natin mamaya at marami pa tayong pag-usapan, Kuya Johan. May bagong USCIS policy na kalalabas lang last week where you can serve the unlawful presence in the United States.
All right. So, napagod yung bahagya kanina, attorney, yung pala kapag overstay ka, even if you're waiting for something, another status, kailangan pa rin umuwi ka sa Pilipinas para makuha mo yung adjustment mo. Like if you're waiting for a green card or something, attorney?
Correct, Kuya Johan. Lalong-lalo yung mga preference category na pag-usapan natin during our last discussion. Ito yung mga F1, F2A, F2B, F3, F4. Ito yung mga family preference category na pinetition kayo ng magulang ninyo, right? At naghihintay kayo ng priority date, right? So, in other words, if you're overstayed, hindi po nyo makukuha ang inyong visa dito. Pero may paraan yan. I-discuss natin mamaya. Ito yung provisional waiver. Pero i-remind din natin, mga kababayan natin, na kahit kayo nag-overstay dito and you decided to overstay, if you marry a United States citizen, ito yung mga exception. If you marry a United States citizen, and number 2, if you have a child or son or daughter over 21, ibig sabihin kayo po ay parent ng US citizen child, right? Pwede po kayo mag-adjust dito sa US kahit overstay kayo. Yun yung exception, Kuya Johan, yung immediate relative, di ba? Mm-hmm. So, or you have children who are still minor, US citizen po kayo at yung anak nyo na nag-overstay dito at below 21 kayo US citizen, pwede rin mag-adjust despite the overstay. Mm-hmm. So yun yung lang exception dun sa ating pinag-usapan ngayon. Hindi sila
nabanggit yung provisional waiver kanina. Meron palang ganito. Who is eligible for this waiver na ito ng 3 or 10 year bar?
Yes, this is a good law, Kuya Johan, where it was created in 2013, panahon ni Barack Obama, where yung mga client natin na nabanggit natin unang-una yung naghintay ng priority date sa kanilang magulang, right? So yung mga preference category, halimbawa pinetition kayo ng inyong nanay, right? And you have to wait for 10 years because you're already over 21. So let's say nandito ka na sa US, pinetition po kayo, hindi ka pwedeng mag-adjust kaagad kasi hindi pa available ang visa, and then hinihintay mo yung priority date. And dumating na yung priority date, attorney, pwede na ba akong mag-green card? The answer there is depends, right? Kung meron kayong, number 1, kung nasa status ka, which is most likely wala na kung hindi ka nag-extend ng status or nag-change into either H1B, which is professional working visa, or student visa. So yung nabanggit natin the last time na pwede kang meron akong client na naging student siya, di ba, for the last 10 years para hintayin yung kanyang priority date, para lang ma-maintain yung kanyang status. So yun yung unang-unang mga mga people who are able to, or applicants who are able to apply for 601A provisional waiver. So ano ba itong provisional waiver? Ito yung hindi mo makakuha ng green card dito sa US, but if you depart, ibig sabihin pag umalis ka sa US, mag-accrue ka ng 10-year bar, 3 or 10-year bar. So ang gagawin yun, ang purpose ng batas, Kuya Johan, is for you to file the waiver now here, right? And then once that is approved, then you have to go home and go to the visa interview. Ito yung, of course, yung medical exam mo sa St. Luke's, and then go to the interview, then kukunin mo yung visa mo. So example, Kuya Johan, let's say pinetition ka ng mother, no, as an F1 citizen si nanay at kayo pa over 21 single. So let's say nakapaghintay ka ng 10 taon, nandito na ka sa US at attorney current na yung visa ko, pwede ba akong mag-green card? So titignan natin kung nag-maintain ka ng status, kung hindi pwede. Meron ka bang 245I, yung pinag-usapan natin ulit dati, yung parang grandfather yon, yung parang protection mo, di ba, para sa overstay. Kung wala, then we do the provisional waiver. So, paano mag-work yun? So, naging available yung visa, sasabihin natin sa NVC na, kasi ang NVC sasabihin na sa'yo, bayaran mo na yung visa fees mo, di ba? And affidavit support, submit all these documents. So, we advise the NVC, the National Visa Center, that the applicant is filing a 601A, yung provisional waiver, para hindi nila i-terminate, Kuya Johan, yung application mo kasi walang action for a year, di ba? So, once the provisional waiver is approved, then babalik ulit sa NVC para kompletihon mo yung mga documentation like affidavit support, civil documents. Then hintayin mo yung interview sa embassy. Kaya patatawag ka. Doon pa lang lalabas, Kuya Johan, or uuwi yung applicant. Pag na-approve na yung provisional waiver at na-process na yung mga civil documents and they already received the visa interview at the embassy. Total, bibigyan naman kayo ng mga 3 weeks to a month, or more than a month, para mag-prepare. So let's say, fast forward natin, nakatanggap na kayo ng interview ngayon saying that you have to attend August 15, for example, visa interview in Manila. Then doon pa lang kayo magde-depart, di ba? At least 2 weeks before the interview para kayo po ay magpa-medical exam sa St. Luke's, and hopefully everything goes well, wala po kayong sakit, wala po kayong mga subject disputing test or psychological evaluation, right? Then go to the embassy and everything goes well, makukuha mo na yung visa mo, right? Probably in 2 weeks time. So para ka lang nagbakasyon, Kuya Johan, sa Pilipinas, di ba? Kasi kung 2 weeks before the interview ka uwi, magpa-medical ka, interview, makuha mo na yung visa in 2 weeks. So parang 1 month. During Obama's time, usually may mga 3 weeks nakakabalik na yung mga kliyente namin. May mga 1 month nakakabalik na, right? Pero during the pandemic kasi ang hirap, may mga administrative delays. So yun yung class of people, Kuya Johan, who can apply for provisional waiver. So yung mga preference category na hindi sila 245I, pangalawa yung mga nag-jump ship, Kuya Johan. So yung mga jump ship na yan, kahit asawa pa nila US citizen, under the law, they cannot adjust status in the US unless 245I. So ang ginagawa natin sa kanila is provisional waiver. Right? And pangatlo, yung mga fiancé visa where yung kanilang petitioner hindi sila pinakasalan, di ba? For example, o nagpakasal, hindi pinailan ng green card, and then nakahanap ulit sila ng asawa, right? Or petition ng magulang at dumating yung panahon na nag-available yung visa o nag-asawa sila ng US citizen. Because this is what the law says, hindi sila pwedeng mag-adjust. Kasi for the fiancé, yung mga K1, they can only get the adjustment or green card through the petitioner. So let's say hindi sila pinakasalan, nag-file ng green card, and they found someone else, a US citizen, nag-petition sa kanila, they cannot adjust here. They should do the provisional unlawful presence bar by filing this packet with USCIS.
Attorney, does getting a provisional waiver guarantee the applicant or the beneficiary that he will end up with a visa, or meron pa ba itong baka biglang may nakita sila sa record mo or something and they can revoke this?
Yes, that's a very possibility, Kuya Johan. That's why, as an immigration attorney, that's why sa mga kababayan natin, before you proceed with the provisional waiver, right, at kahit ma-approve yan, there's no guarantee that you're able to get the visa. So what we do as practitioners, Kuya Johan, we pull out the records ng aplikante sa USCIS kasi lalo na matagal na sila dito. For example, ano yung kanilang mga immigration violation, may mga application pala sila sa USCIS na hindi sinasabi sa atin na fraudulent, right? Or meron silang fraud, entry in the US, ibang pangalan ang ginamit, or at one point nag-file sila ng work permit na based on a fraudulent claim. So we exercise what we call due diligence kasi mahirap, Kuya Johan, ang may stock ang mga aplikante sa home country nila, lalo na mga Southern American clients where they can just cross the border anytime, right? So okay lang kung single entry yan, one time na enter without inspection. Pero kung mga multiple entries, nahuli sila, they were expeditedly removed or turn around, ang sinasabi natin, tapos pumasok ulit sila, they're not eligible. Kasi ang provisional waiver, Kuya Johan, isa lang pinapatawad dyan. Diba? Yung overstay mo, right? O yung single EU entry mo. So kung may multiple entry ka or may other violations ka, kagaya ng meron kang fraud application sa CIS, sa USCIS, or meron kang criminal records, na na subject to a waiver, hindi po pwede kasi as I mentioned, the provisional waiver can only pardon one violation, which is your unlawful presence, which is your overstay, right, or you're entered without inspection. So very careful po tayo dyan. So what we do is to evaluate your file before we send you home, right? Kasi ang hirap, Kuya Johan, yung stuck ka, and I've seen clients in the past where 10-year bar pala sila, or no, not 10-year bar, but they are subject to another bar, or meron tinatawag na lifetime ban pa, di ba? Yung pumasok sa dito and then umalis, may deportation, tapos pumasok, nakailang entry sila dito. So meron tinatawag na lifetime ban, meron tinatawag na another ground of inadmissibility. So if that happens, let's say, pumunta kayo sa interview, right? Very common to sa mga crewman. Right, so crewman, for example, nandito sila, nag-jump ship. Nakahanap ng US citizen spouse, na-approve yung petition, na-approve yung provisional waiver. Right? Dahil nagkaroon sila ng anak and, the US citizen spouse is dependent on the applicant. So na-approve yan, umuwi. Pagkatapos ng interview, for example, or during the interview, sinabi niya, talagang plano kong hindi ako actually crewman. Diba? Parang ginamit ko lang itong aking, or nag-hire ako ng agency para makakuha ng visa, or hindi naman talaga ako magjo-join ng ship. So in that situation, mayroong another ground of inadmissibility dyan, not just the being a crewman na nag-jump ship, but also what we call misrepresentation or fraud, diba? Kasi parang gumamit ka ng visa to enter the US, just to enter the US, which is the C1 crewman visa. So be very careful, mga kababayan, especially if you do this process. Most of our cases naman, Kuya Johan, 95% of the time, na-approve at walang kaanong issue. Nagkakaroon lang ng konting delay sa embassy dahil either nagkaroon ng medical problem sa kanilang medical exam and they require them to do sputum test, right, or psychological evaluation, or may mga ilan na you committed fraud despite the preparation sa mga kababayan natin. Minsan, sometimes they say something that they think are helpful to their case na hindi naman. Right, so then the immigration would say, we're going to revoke the provisional waiver approval, right? And you are subject to another ground of inadmissibility, which is fraud or misrepresentation. In that scenario, mga kababayan, hindi naman end of the world. You can still file another waiver, but you have to wait for the processing time, which might take about a year.
Attorney, ilan sa mga itinatanong na mga listeners ngayon is, the reason in the first place kung bakit sila nag-overstay. For example, nabanggit nyo kanina, yung pandemic, hindi sila makaalis or something like that. What if nandito sila, attorney, at merong mga hardships na hindi nila maiwanan ng kanilang relative, no? Or especially kung medyo senior relative, kailangan sila dito, kailangan ng tulong nila. And that's the reason why overstay sila in the first place. Is there can you use that as an excuse? Sabihin mo na, meron akong extreme hardship at kaya hindi ako nakaalis.
You still have to file an extension para kung ayaw mo mag-accrue ng unlawful presence, ayaw mo mag-accrue ng unlawful presence, you have to file an extension before mag-expire. Diba? There are situations where you can say that I was not able to go home right away dahil nagka-COVID ang parent ko or magulang ko at I have to take care of them, bring them to the hospital. So you still have to be, be very alert, that be very conscious yung expiration ng visa mo. Diba? Ideally, legally, you should file it bago mag-expire. Kasi pag nag-file ka ng extension, Kuya Johan, na expired na yung visa mo, there's nothing to extend, sasabihin ng immigration sa'yo. Right? Because expired na. So, if there's hardship, it's still a good excuse, Kuya Johan, to file that extension. There are scenarios where, for example, dumating sa amin yung mga applicants o mga kliyente where turn expired na yung aking status last week or last month, but I have to take care of my parents, di ba? So we can always file an extension, exception to the rule. Alam mo naman sa batas, Kuya Johan, mga abogado, very creative yan, di ba? So paano yan? As we mentioned, general rule, you cannot extend an expired status, right? So what we do is what we call the non-protonc, where it reverts back to the time na nag-expire. So we are requesting them na, let's say, nag-expire yung status mo, yung visa mo noong July 1, July 12 na tayo, July 13 na tayo ngayon. Diba? So, paano yan? There's nothing to extend. But we're requesting them ng protonc, meaning pwede ba ang extension namin starts nung nag-expire, which is July 1. So those are also allowed under extraordinary circumstances and exceptional circumstances where you have to discuss with your attorney, the reason why you failed to file extension on time.
That's the reason why, mga kaibigan, we'll take this opportunity to remind you kung paano nyo makokontak ang ating mga kaibigan sa Reeves Immigration Law Group. Especially meron silang bagong office in California. So alamin natin, we'll be right back, attorney. We'll take a short break. And pagbalik natin, pag-usapan naman natin ng iba pang mga issues regarding the 3 and 10-year bar. And like what you said, there's a brand new development with regards to the application of the 3 and 10-year bar. And katulad ng nasabi ni attorney kanina, kailangang maintindihan natin lahat at kailangang you're on your toes, so to speak, that talagang nakatuto kayo sa inyong status, and especially knowing if this 3 and 10-year bar affects you. Kaya magandang kumonsulta at tumawag sa ating mga kaibigan sa Reeves Immigration Law Group. So we'll remind you on how to contact them on this break. We will be right back sa ating Immigration Law on your side pagkatapos lamang nito. Diyan lamang po kayo.
Reeves Immigration Law Group has been representing immigrants for nearly 40 years. Reeves Immigration Law Group has been fighting for its clients through experience and expertise. With immigration lawyers you can access at reasonable fees, even on Saturday. Payment plans are also available. Call us for your immigration solutions. We can do worldwide telephone and Skype consultations. Reeves Immigration Law Group, 1-800-795-8009. Reeves Immigration Law Group has offices in Los Angeles, San Francisco, China, and Philippines. See us at www.rreeves.com. Reeves Immigration Law Group, 1-800-795-8009.
All right, welcome back to Immigration Law on your side right here at PHLV Radio. We are streaming from Las Vegas, Nevada. Nanggagaling po kami sa PHLV Radio Studio. And ang ating kaibigang si Attorney Fil-Am Javier Diza, partner at Reeves Immigration Law Group, and nanggagaling po sa San Francisco, California. Before we headed to a break, we teased you into this brand new guidance from the USCIS, like what Attorney said on top of the program, with regards to the 3 and 10-year bar. We're excited to find out, attorney, kung ano itong latest development na ito. Mabigyan natin ng briefing ang ating mga tagapakinig.
Yes, Kuya Johan, very good news sa ating mga kababayan na nandito sa United States, where in the past they have accrued unlawful presence, right? So marami sa mga kababayan natin, Kuya Johan, let's say they stayed here for over a year sa America and then they left the US. That means meron silang 10-year bar. Pero for whatever reason, nakabalik sila, di ba? So ang requirement kasi ng batas, Kuya Johan, is you have to serve, ang 10-year or 3-year bar outside the US from the time nang depart ka. So kung umalis ka ng 2010, 2020 ka pa makakabalik, di ba? Makapag-apply ng visa. And for whatever reason, may mga kababayan tayo, right? Hindi lang naman mga Pilipino, kundi pati mga from American, from Southern American clients where they cross the border, anytime. But what I'm saying is, the law now although in the past requires that you have to serve the bar outside the US, on June 24, very fresh pa ito, Kuya Johan, 2022, ang USCIS issued a guidance, that the 3 and the 10-year bar continue to run, even if the person returns to the US. So that's a good, in a way, good news, Kuya Johan. So for example, so si Juan, nag-stay dito, nag-overstay ng more than a year, right? Meron siyang tourist visa, nag-stay. Sabi niya, I have to go home dahil may sakit ang aking tatay. I have to be with him. So umuwi siya, let's say, kailan ba? 2010, right? And then, nung gumaling father niya, for example, nag-apply ulit siya ng visa, right? At either in the past kasi madaling mag-apply, Kuya Johan, or kahit sabihin mong wala kang status, minsan na-check in the past. But now with all the technology and at internet and access ng ang database ng USCIS, nakikita nila may overstay ka. But in the past, madaling ma-check, di ba? Ma-check kung nandito ka sa US at one point. So nakabalik sa ngayon sa US, wala pang 10 years. And then nakahanap siya ng asawa. So what we do advise sa mga client natin, you cannot adjust you kasi may violation kang 10-year bar. You have to serve yung bar sa Pilipinas. So hindi pa yan, wala pang 10-year bar. So let's say 2015, nakabalik na si Juan ulit sa US, either probably being truthful sa kanyang application at sinabi niya na I had a visa before but it was already gone. It's gone. At for a miracle, binigyan siya ng embassy ng another visa. Or probably si Juan might have used a different name. Or probably si Juan entered without inspection, nag-cross siya ng Mexico, and not sa America na siya. So 2015 dumating si Juan, and then let's say fast forward natin, ang batas dapat hindi pa niya na-serve, diba? So hindi siya pwede mag-adjust. But after 2025, which is 10 years from 2015, na-serve na niya yung 10-year bar at pwede na siya mag-adjust. So that's in a way good news sa mga kababayan natin who came here. Marami sa mga kababayan natin, Kuya Johan, ganyan ang sitwasyon din minsan medyo maabilidad ang mga kababayan natin that they are able to come back, either under the real name or under different name. So yun yung batas, Kuya Johan. Now, ang isang tanong dyan is, paano kung ayaw mong hintayin yung 10-year bar? Diba? Let's say nandito na sa US at na mayroon siyang asawa ngayon, pwede ba siya mag-adjust? So the rule is, generally no, kasi hindi pa nasa-serve yung 10-year bar. There is what we call at I-212, which is permission to reapply. Then we can also apply that. But kind of waiver then, same as you have to prove hardship sa family member mo. So yun yung bagong batas, Kuya Johan, sa 3 and 10-year bar. Going back dun sa provisional waiver natin kanina, aside from having a qualifying relative, kasi hindi lahat yan, Kuya Johan, nakakapag-avail ng provisional waiver. So let's say may mga employment petitioner kayo, attorney, overstay na ako sa Amerika, wala akong asawa, wala akong anak ng petition sa akin, wala ring petition na magulang sa akin. So willing yung aking employer na petitionin ako, right? Pero overstay ako. Can I still proceed? Now, titignan natin, general ang sasabihin natin is no, kasi overstay ka. Ayaw mong sayangin yung pera mo dun sa petition, right? At umasa na magkakaroon ulit ng another 245I. Now, but kung meron kang magulang, kasi kailangan mo ng qualifying relative, di ba? Wala kang kasama yung magulang, kakararating lang halimbawa, right? Or mayroon kang kapatid na US citizen at plano ninyong i-petition ang magulang ninyo para mag-immigrate sa US. Posible yon. So yung employer can still continue petitioning you, right? Once na ma-approve yung labor certification at yung visa or yung I-140, hindi ka pwede mag-adjust dahil overstay ka. Pwede nating i-file yung provisional waiver if you have a parent, right? A father or a mother who's a lawful permanent resident in the US, right, or US citizen, who would suffer extreme hardship. So isang ipoprove natin yan, Kuya, yung extreme hardship, right? And as we mentioned kanina, yun yung paraan para ma-approve yung waiver mo. You have to have a visa available. You have to have a family member who's what we call qualifying relative, which is spouse, US citizen or lawful permanent resident, and those or parent Those qualifying relative would suffer extreme hardship. So hindi porket meron kang magulang dito, let's say nakatira ka sa California, right? Nakatira sa Nevada yung magulang mo, then it's not going to work because you cannot prove hardship dun sa magulang. So yun ang very important na alamin ng mga kababayan natin, right? When they file for the provisional waiver.
Wow, okay. So yan. Mga kaibigan, take note because ito, malaking information ito para sa ating mga kababayan, especially yung may mga parents dito, katulad nga ng nasabi ni Attorney Diza. Attorney, kung ang ating mga kababayan ay medyo, we spoke to a few people who are parang natatakot silang magkonsulta, overstay na sila and everything. Should they still call you sa law office natin? Safe ba sila? Yun ang mga tanong nila pagka ganun na overstay na sila, attorney.
Very safe po ang law firm namin and any law firm for that matter kasi number one, we maintain attorney-client confidentiality. So hindi po tayo law enforcement, di ba? So huwag kayong matakot sa amin. We are here to help you. Yun ang isipin po ninyo sa abogado. Wag din po yung makatakot. Baka akala nyo masyado kami mahal maningil. Right? Minsan natatakot mga kliyente mag-consult dahil masyadong mahal. And then when they found out na we have payment plans naman, di ba? In case you have a good case, we push you to proceed whether with our firm or with someone else and to start, processing and applying your case by either, requesting your form from USCIS. Our law firm, Kuya Johan, right, and we just opened a new one as you mentioned kanina sa Walnut Creek, and we've been getting a lot of clients in person. They really wanted to see us in person as we advertise in newspaper and radio that people wanting to see us in Walnut Creek, we charge free consultation. And even if you hear us from PHLV radio, you can also say, can you waive the consultation fee? We are always willing to accept kung yung request po ninyo. If it's hard for you to pay the $100, then you can always waive that as well. And yes, all the partners at Reeves Immigration Law Group, Kuya Johan, are immigration law specialists, meaning that we are certified by the state bar, that we are specialist on our field. So don't worry, don't be afraid to call us. We are here to help. You have the number at 415-568-377. You'll be speaking with immigration attorney and certified specialist in immigration.
And habang pinost natin ito, na topic na ito, marami, we have a program sa mga OFW, para sa mga OFW. Isa sa mga scenario na ibinato sa atin attorney, sabi niya, may tanong mo naman kay attorney. Sige, tatanong natin. Kaya kung may mga tanong po kayo, just i-comment nyo lang dito. Hindi man umabot sa program natin yon, makakarating po kay Attorney Diza. Isang OFW, dating meron siyang bar, pero nung uwi sa Pilipinas, nagkaroon siya ng opportunity na maging OFW sa ibang lugar, attorney. Nasa UAE siya ngayon. Ito bang pagsuserve ng 10-year bar or 3-year bar ay dapat nasa home country ka lang or okay lang na nandoon ka sa Dubai ngayon at naninilbihan bilang OFW, and then when you have served the amount of time, can you reapply for the United States?
That's a really good question, Kuya Johan, and the answer there is no, you don't have to be in your home country to serve the 10-year bar. So ang requirement ng batas is as long as you serve outside of the US. So kung nasa Mexico kayo, Canada, nasa tabi lang kayo ng US, nasa Dubai, nasa Pilipinas, during those 10 years, you traveled, everywhere, then you have served the 10-year bar. And as I said, yes, as long as more than 10 years na po kayo outside the US, you can reapply again. Now, the other scenario here, Kuya Johan, is yung mga gustong-gusto nang bumalik ka agad. Kasi ang bar nga pala, before I forget, hindi lang yung mga nag-overstay, right? One of the scenarios na nababar din sila, Kuya Johan, yung mayroong expedited removal. Naalala mo yung airport to airport, right, where nahuli na nagtatrabaho minsan, nahuli na iba palang intent, and then the CBP at the border determined that there was a violation, so nireject yung kanyang admission and nagkaroon ng airport to airport o yung expedited removal. They are also barred for 3 years. So in that situation, kahit wala pang 3 years or 10 years, pwede pa rin kayo mag-re-apply ng tourist visa, right? Keep that in mind. Pwede mag-re-apply. But as tatanong mo, attorney, 10-year bar ako, 3-year bar ako. yes, if you have a good reason to come here, merong waiver yan. Hindi lang yung may asawa at may anak dun sa immigrant, yung pinag-usapan natin kanina, provisional waiver, para sa mga immigrant yun. Pero sa mga non-immigrant attorney, nakahanap ako ng employer H-1B, pero akong student visa, gusto ko mag-tourist visa. As long as you're able to prove yung intent mo to come here on either of those non-immigrant, right? But you go to the interview, mag-set ka ng appointment kahit may bar ka, and then the embassy would say, hey, you are qualified for a tourist visa dahil may restaurant ka naman dito, malaking business mo, right? Meron kang properties. But I cannot give you the visa now, but you have to file a waiver. Doon po mapasok yung other waiver na I think at one point we discussed yung non-immigrant visa waiver. Ito yung D3 waiver. So posible yun mga kababayan. So don't wait for the bar to lapse before you apply or reapply for a non-immigrant visa. You can do that. Hindi mo kailangan ng qualifying relative. You just need to show that there has been that your what do you call this? Your presence in the US is important, and you have to. It's a very liberal waiver that you can actually file through the help of our law firm.
All right, amazing information mga kababayan. Kasi alam niyo na, pagka nasabi yung 10-year bar or 3-year bar, parang end of the world na sa karamihan pag nalaman nila yan. And speaking about that, attorneys, mga kababayan natin, nasa Pilipinas, nagkaroon ng ganitong problema, we have an office in Makati, attorney, di ba? Pwede silang kumonsulta doon sa mga attorneys natin sa Reeves Immigration Law Group sa Makati.
They have to coordinate with our Makati staff, Kuya Johan. They will be speaking with a US immigration attorney through Zoom. Right, yun po ang paraan. That's one of the advantages of our law firm, Kuya Johan, dahil if you hire our services, we have staff in Makati who would help them schedule an interview, follow up, call the embassy, call St. Luke's, call use PIDOS and everything. So very helpful yan, Kuya Johan. But I guarantee sa mga kababayan natin that when they speak to about their immigration concern, they will be talking to an immigration lawyer in the United States.
All right. Amazing. Attorney, maraming salamat muli po sa inyong mga information na ibinigay sa ating mga kababayan regarding this hot topic na ito. Alam mo, itong mga conversations na ganito, attorney, minsan napapag-usapan pero parang nakakatakot bang magtanong regarding this. At kaya mga kaibigan na nabigyan ng linaw. Attorney, I'll give you this floor to wrap things up in case meron pa po kayong ibang takeaways para sa ating mga kababayan.
It's always my pleasure and honor to be here, Kuya Johan, at PHLV Radio for doing this public service sa mga kababayan natin. Reminder na rin sa mga listeners and viewers natin that this is only for informational purposes only. It doesn't serve as a legal advice. Every case is unique and you have to consult an immigration attorney, whether through us, to us, or any immigration attorney regarding your situation para ma-assess po natin kung ano ang tamang landas na tatahakin ninyo regarding your immigration problems. Maraming salamat ulit, Kuya Johan, at shout out po na rin sa aking bunsong kapatid, si Dr. Juliet Diza Rivera. Birthday niya ngayon.
Happy birthday!
Sa Quezon City. Maraming salamat ulit at mabuhay kayong lahat. At kung mayroon po kayong mga gustong topic na i-discuss natin, then let us know. Message niyo po kami ni Kuya Johan.
All right.
Mabuhay.
Mabuhay kayo, Attorney Diza, and pinost na rin ni Attorney Diza ang ating mga naging topics over the many episodes na ginawa natin sa Immigration Law on Your Side. Mangyari lamang pong puntahan ang kanyang Facebook page or ang website din ng Reeves Immigration Law Group. So Attorney, bago tayo magtapos, we'd like to greet you again. Belated happy birthday once again from your family here sa PHLV Radio sa Las Vegas. Ang tanong nila ay, kailan kayo pupunta uli dito sa Vegas?
Pag pumunta ako dyan, sasabihan ko kayo, let's get together for coffee or lunch.
All right. Or dinner. All right.
Yes.
The best. Maraming salamat po, Attorney Diza. Again, nagagaling po dito sa Las Vegas, Nevada, si Kuya Johan po. At ako po ay nandito sa PHLV Radio Station sa Las Vegas, Nevada, 3909 South Maryland Parkway, Suite 15. 215 Las Vegas, Nevada, 89119. Kung meron po kayong mga sulat, mga suggestions o kaya mga topics na gusto nyong matackle namin ni Attorney Diza. Hanggang sa muli po, ito po ang Immigration Law on Your Side, hatid sa inyo ng Reeves Immigration Law Group. We will see you next time.
Reeves Immigration Law Group has just brought you Immigration Law on Your Side. Wednesdays, 7 p.m. Pacific on PHLV Radio.
Reeves Immigration Law Group has been representing immigrants for nearly 40 years. Reeves Immigration Law Group has been fighting for its clients through experience and expertise. With immigration lawyers you can access at reasonable fees, even on Saturday. Payment plans are also available. Call us for your immigration solutions. We can do worldwide telephone and Skype consultations. Reeves Immigration Law Group, 1-800-795-8009. Reeves Immigration Law Group has offices in Los Angeles, San Francisco, China, and Philippines. See us at www.rreeves.com. Reeves Immigration Law Group, 1-800-795-8009.
Just like a friend from back home.
This is your Filipino radio experience in Las Vegas. PHLV Radio.
PHLV.